Hi there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. Today, this video discusses top 4 estate planning questions to answer when using assisted reproductive technology. Now, welcoming a child into the family is a major milestone in every parent's life, especially if you have utilized assisted reproductive technology, or otherwise known as ART. With this blessing comes a need for comprehensive financial and estate plans that are uniquely tailored to your family's needs. As you continue your journey, we want to provide you with the answers to some questions that you may not have thought about, or that you may actually have regarding your family. The very first question is, when should you start planning for your child? Well, from a financial perspective, now is a good time to start planning for your new one. As you probably are aware, the ART process can be expensive. Having a proper financial plan can help alleviate some of the worries you may have during the process. Now, raising a child is also expensive. The cost of food, clothing, shelter, toys, and education must also be considered. Even if you're not expecting a child imminently, setting money aside or preparing a budget to accommodate these expenses can put you on the right financial path. Now, when it comes to addressing your child and your estate plan, including who will be the child's guardian if something should happen to you, how much money the child should receive, and when the child will receive the inheritance, it is best to wait until the child will soon be born. While you can plan for a potential child, your estate planning documents will be clearer if you plan for things as they are at the time that they are drafted. However, you can still create an estate plan now and change your plan when a child is born. Creating an estate plan is not a one-and-done event, and it must continue to change and evolve as you and your family circumstances do the same. Another question that people often have is, what will happen to my genetic material when I pass away? As part of the ART process, you or your spouse or your partner may store genetic material, so whether it's sperm or eggs or embryos, for future use. It is important that you review the forms you signed with your doctor or the facility to know what will happen to genetic material if you or your spouse or your partner dies. Typical options include destroying, donating, or transferring ownership to someone else that you have named. In many states, the courts will defer to what is in that form that you actually signed. It's important that you know what it says and that you agree with the outcome before signing it. You must also know what you need to do if you change your mind. And what happens if a child is born after the genetic parent has died? A question that comes up is, can that child inherit from their deceased parent? With advancements in modern medicine, a child could be born years after a parent has died using the genetic material of the deceased parent. However, the right of the child to inherit from that deceased parent is based on each state's laws. A variety of factors can impact the child's ability to inherit, such as how long after the parent's death the child was born, and whether the deceased parent consented to the use of their genetic material after their death. So another question that people have is, do I really need to work with an estate planning attorney in regards to this? Well, while do-it-yourself options may seem cheaper and more convenient than working with an attorney, an experienced estate planning attorney can make sure that your estate plan is crafted to address your unique circumstances. Custom language, as opposed to boilerplate definitions for terms, can alleviate confusion about who you want to receive your money and property and how you want them to receive it after you've passed. And although the terms parent and child have standard definitions that are understood by most people, they may have different meanings for your family. For example, does the term parent refer to the biological parent, the gestational parent, the adopted parent, or the spouse of a parent? Assuming that a parent is the person that provides genetic material may leave out an important person from your estate plan. Similarly, the term child can have different meanings in different circumstances. Does the child include biological children, adopted children, or a stepchild? You may consider someone your child, but you may make sure that your documents properly define that person as your child. Lastly, because of the use of art is becoming more common, the definition of the term descendants might be impacted, not only in your plan, but for other families as well. Do you want your child's child that was conceived by art to be considered your grandchild, even if there is no genetic link to your child? So I understand that your journey to parenthood may be long with twists and turns and highs and lows. And we respect your privacy and just strive to craft a plan that expresses your wishes in a legally enforceable way that will protect you and your family and avoid family conflict. If you live in Mass and New Hampshire, we are happy to help you with this, so please call and schedule your appointment. Or otherwise, call an experienced estate planning attorney that will be able to craft and create a plan that meets your unique needs. I want to thank you for watching. I hope you all found this helpful, especially if you're going through the app process right now or thinking about going through the app process. I'm attorney Kelly Longtin, founder of Kelly Longtin Law.